Hi everyone, this is Dave Stauss. I'm a data privacy partner at Hush Blackwell. I'd like to thank you for listening to our on-demand webinar. Today we're going to discuss the CCPA's draft regulations with respect to automated decision-making technology. Now, if you've attended one of our prior webinars, you know we like to provide a roadmap for where our webinars are going. Today's webinar will provide an overview of the rulemaking process. It will then discuss the ADMT draft regulations specifically, and it will talk about what is covered by those regulations and the new requirements that they create. Okay, so turning to our first topic, and given that this is our first webinar and what I'm about to explain is a series of webinars, we wanted to provide an overview of the rulemaking process and provide you with some thoughts on the timing for when these new regulations could go into effect, which is probably the question that's on a lot of people's minds. So, as a starting point, the last round of rulemaking, this latest round, I should say, of rulemaking covers 5 topics. There are revisions to the existing regulations, and then there are 4 new areas of regulations. As I mentioned before, the plan is to do a webinar on the first 4 topics. Keep in mind, though, that these are draft regulations and they are likely to change. They will be, as we'll explain in a second, they'll be subject to comment period and revisions. So the goal with these webinars is really just to provide the listener with a high-level summary of what's in the regulations for each topic. We're not going to try to dig in to specific details about them, but just to give you an understanding of what's happening. And we're going to try to keep these webinars to, 15, 20 minutes or less. At the end of the day, it just doesn't make sense at this point in time to dig into all the nuances of these draft regulations because, again, they are drafts and they are likely to change, and we can always follow up later and do a webinar on the final regulations. Okay, so in September 2022, the agency prepared this chart that I'm showing you here, which shows the rulemaking process. Now, as of November 8th, the agency board moved forward with the rulemaking process, and so now we are at the end of that pre-rulemaking portion of this proposed process here. The next step will be for the agency staff to prepare the notice of proposed rulemaking and get that filed, and once that is done, that will kick off a 45-day comment period and then a public hearing. Staff will then consider changes to the rules, to the draft rules that we're going to talk about in a second, and it's possible that there could be additional comment period or public hearing. That really depends upon what the changes, if any, are that result from that 45-day public comment period. If the agency comes back, the staff comes back, and it's made substantial and sufficiently related changes, then there needs to be another 15-day comment period. However, if the changes are substantial but not sufficiently related, then there needs to be another 45-day comment period. And obviously, if nothing changes, then there's no comment period. So our options here are 0 additional comments periods, 15 days, or 45 days. Now, after the text is done, it needs to be voted on by the board, and then if the board votes and passes it, it goes to the Office of Administrative Law for review, and OAL has 30 days to conduct a review. The regulations then go into effect upon approval. You may recall that there was some court decisions before about how quickly the regulations would go into new regulations would go into effect, and where we've landed right now is that the regulations go into effect upon approval by the OAL. Okay. Moving on, if you would like additional information on the rulemaking process, you can review these FAQs that are put out by the Office of Administrative Law's website. Now, I think there will be a lot of curiosity as to when these regulations could go into effect. Obviously, that is a matter of speculation. We don't know quite yet how long the process will take, but we do have some prior rulemaking examples that we can look to at least provide some guidance here. So the first round of rulemaking the agency engaged in, it took a total of 264 days from the time formal rulemaking was initiated until the OAL approved those regulations. So that's, give or take, that's almost 9 months from start to finish. The second set of regulations are the data broker regulations. We are near the end of that process. Those regulations still need to be submitted to the Office of Administrative Law for review and approval. However, if you look at the time for the CCPA regulations, it took 54 days between board approval and final approval. So if you assume it will be another 50 days until, give or take, until OAL approves the data broker regulations, then you're looking at around 180 days or 6 months. Now, the big distinction between these two is if you look at the comment periods, the CCPA regulations had a 45-day comment period followed by a 15-day comment period, and then the data broker regulations just had that one 45-day comment period. So ultimately, if you're in the prediction business, and it's hard to predict these things, but if you're in the prediction business, you're looking at somewhere between 6 to 9 months range based on this data that we're looking at here. Again, if the comment periods were longer, then you'd be looking at a longer comment period. But, as best as we can tell, that would place us somewhere in the May to August 2024 time frame for these regulations to be finalized. But again, we are engaging in pure speculation. Want to be upfront about that one, but at least it gives you some sense based on history of where we could land. Okay. So let's pivot now and talk about what is covered by these ADMT regulations. So generally speaking, what you need is you need ADMT, you need automated decision-making technology. We're about to talk about what that means. And then it needs to be one of three things. It needs to be a significant decision concerning a consumer, extensive profiling, or training uses of ADMT. So generally speaking, you need this calculus here for these new ADMT regulations to apply. Okay. So first, let's take a look at the definition of automated decision-making technology, or ADMT as we're calling it. Now, the agency issued a fact sheet when it was engaged in the pre-rulemaking process. And what it explained, that the fact sheet is useful to take a look at because it kind of cuts to the chase on a number of topics. But what it explained is, quote, ADMT is technology that makes decisions or that a person relies upon to make a decision. It includes profiling, which generally refers to evaluating consumers by automated means, for example, using technology to analyze their personality, interests, behavior, or location. Artificial intelligence can be ADMT, but not all AI is ADMT. Now, if you look at the draft regulations, ADMT is defined to exclude certain things like web hosting, networking, firewalls, and that's similar language as to what we find in the Colorado AI Act. Notably, if you look at the definition, specific wording there, it says any technology that processes personal information and uses computation to execute a decision, replace human decision-making, or substantially facilitate human decision-making. The regulations also include a definition of substantially facilitate human decision-making. Okay. I mentioned earlier that ADMT includes profiling, and then the regulations also include a definition of profiling, which is similar to what we see with respect to the Washington Privacy Act variants. So, for example, it's this language of any form of automated processing of personal information to evaluate certain personal aspects, in particular to analyze or predict aspects concerning intelligence, ability, aptitude, performance at work, health, mental health, personal preferences, predispositions, etc. Okay. So moving on, as mentioned before, the agency had issued a fact sheet in the pre-rulemaking activities. And in that fact sheet, the agency gives 3 examples of what it considers to be ADMT, right? So first, a resume screening tool that a business uses to decide which applicants they will hire. The second example they give is facial recognition technology that the business used to verify the identity of consumers as they enter into a workplace. And then the third example they give would be tools that place consumers into an audience groups to target ads to them. And this targeted advertising is something that comes up in a minute, and we'll just talk about it when it arises. Now, as we noted on the applicability page a few slides ago, you have to use ADMT for one of these 3 activities, right? So it's not enough that it's just ADMT. It has to be one of those 3 categories, the first one of which is significant decisions. So privacy professionals will recognize this category and feel very similar to what we see with like Colorado and Connecticut laws. that have the right to opt out of profiling, right? One caveat, though, is that you have to use information that's not subject to the CCPA's exemptions or exceptions. In other words, if the data is outside the CCPA, then that data is excluded. So there's a real scoping issue, right? So for example, you see here we've carved out financial or lending services. So you'd have these rights that I'm going to explain to you in a minute, including the right to opt out of ADMT that's used for financial or lending services. But keep in mind that the CCPA has a data level exemption for GLBA data, right? So again, we run into this issue about making sure that there's this crosswalk between the data that's actually covered by CCPA, and that's at the end of the day what confines the contours of this. It is again a regulation that stems out of the CCPA. The exemptions and the exceptions are going to apply. As you see as well, these significant decisions, they involve things like housing, insurance, education, employment, and enrollment. A lot of the same things that you will see not only with respect to these Washington Privacy Act variant models, laws I should say, that have passed in other states of Colorado and Connecticut, but also when you do the parallel between the Colorado AI Act and you look at what is a consequential decision under the Colorado AI Act. So again, drawing parallels between these different regulatory regimes. Okay. The second category, again, if you think back to that applicability slide at ADMT plus 1, 2, or 3 categories, the second category is extensive profiling. There are 3 categories that are listed in the regulations for extensive profiling. First is worker education profiling, and the regulations explain that that's profiling a consumer through systemic observation when they are acting in their capacity as an applicant to an educational program, job applicant, student, employer, independent contractor. Keep in mind, of course, that the CCPA now covers employee data. Next is public profiling, and the regulations explain that is profiling a consumer through systemic observation of a publicly accessible place. And finally is profiling a consumer for behavioral advertising. So the regulations there explain that it is targeted advertising to consumers based on their information obtained from the consumer's activity, both across businesses, distinctly branded websites, applications, or services, and within the business's own distinctly branded websites, applications, or services. And that latter part there, within the business's own distinctly branded websites, applications, or services, is a place in which I think there'll be a lot of focus and attention, because that goes beyond what we would think about sharing or targeted advertising. It is across businesses, not within businesses. And again, these are draft regulations. We'll see where things land. Finally, worth keeping in mind that we'll talk about risk assessment regulations, the draft ones, in a later webinar, but wanted to note here that extensive profiling would also trigger that risk assessment requirement. Okay, the third category, again, ADMT plus 1 of these 3 things. The third category is training ADMT. And here the regulation gives 4 categories. So this is if you are, again, kind of to give a frame of reference, this is if you're using personal information to train ADMT to do any of these 4 categories here. Now, it's worth noting the regulations contain a separate section for when businesses use physical or biological identification or profiling. We won't get into that section in this summary webinar, but again, worth noting that that's out there. So then, if it applies, the question is, what do you need to do, right? Well, 3 things that you would need to do. 1, provide a pre-use notice. 2, provide a right to opt out. And then 3, provide the right to access ADMT. So let's go through each of these pretty quickly. So the pre-use notice, this is in general, you need to provide notice before you use personal information for ADMT. You need to explain the purpose of using ADMT and how it works, and you need to tell people what their rights are. I think ultimately here what the issue, I mean, there's going to be a lot of proposed comments, don't get me wrong, but I think really a lot of focus here is going to be one that will receive a lot of comments in the discussion period is going to be this how ADMT works, one. And I think companies will claim that explaining how their ADMT works is going to be a violation of their trade secret rights, which is what we saw the debate on with respect to the Colorado AI Act. And so ultimately what they're going to end up saying is, hey, we can't tell you exactly how our ADMT works, because that's business proprietary and we shouldn't have to disclose those things. And we'll see eventually where that lands. But again, the first requirement at the end of the day is to provide a pre-use notice, and the regulations go into things about like how that notice should be provided to people, and that's going to feel very familiar to you if you're familiar with the regulations, these concepts of these like notice at collection type concepts, these upfront notices. Okay. The second thing is that consumers have the right to opt out of ADMT. That's the general rule. There are a number of exceptions, 3 in particular. At least the fact sheet, I should say, that's provided by the agency groups these into 3 exceptions. First one is that the ADMT is used for security, fraud prevention, or safety purposes, and there's a sub-definition there, which you would really need to take a look at to make sure that it applies there. The second one is if ADMT is used for a significant decision, and business provides consumers with a method to appeal the decision to a qualified human reviewer. So like a human appeal, right? And there's some aspects there I think that kind of bleed through with the Colorado AI Act. Remember, there's not the right to opt out. With the Colorado AI Act, there's the right to appeal. Third, if ADMT is used for certain kinds of significant decisions like admission or hiring, and then the business has to evaluate the ADMT to ensure that it worked as intended, that's going to work as intended, I should say, and it's not discriminatory, and the business also has to put safeguards in place to ensure that. So again, general rule is you have the right to opt out of it, but there are some exceptions here that businesses could look to, at least in its draft form now. Okay, so finally, last slide, you would also have the right to access ADMT. So this is the third requirement, and there is one exception here that's relevant, which is unless the ADMT is used solely for training uses. So basically what ends up happening is you have the right to submit a request to access, and the regulations go into like how this request would be received. And I should note in the prior slide as well, the right to opt out, there's also regulations on how that request would be received, things, like 2 methods of receiving requests, those types of things are in the regulations. Here with the request to access, in addition, the disclosure has to be, at the end of the day, if the consumer makes the request, basically is, how was my information, how was ADMT used with respect to me, right? So your disclosure has to be specific to the consumer. So here you would be identifying in response the purpose of using, the business's purpose of using ADMT, the output of the ADMT, again, specific to the consumer, how that output was used by the business, and how it worked with respect to the consumer. And you'd also have to tell the consumer they cannot be retaliated against for exercising their rights. Okay, so that's our webinar for today, at least with respect to ADMT. We look forward to bringing you our next webinar in our series, and stay tuned. Thanks so much.